Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Answer and Evaluate. As a bit of background, we at Digital Law are a niche law firm specialising in working solely in technology and cybersecurity law sector. In each episode, we look at recent stories in the news relating to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we are covering this week, please check the links in our show notes. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by Peter Wright. Peter, would you like to introduce yourself? And then we will get started.
Hi everyone, my name is Peter. I'm a solicitor and the Managing Director at Digital Law. I'm looking forward to discussing a few of the many useful, interesting law and technology related things in the news over the last couple of weeks, to the point we've had to prune a lot of them out just to get down to the few stories we're going to look at today. So this is very much the sort of the cherries on the cake for you. So I'll pass back to Amelia to start us off.
Thanks, Peter. So in terms of what we're going to cover today, we are going to cover Linklaters making a robot sit the law exam to pass the quality of advice, then looking at law firms' use of AI, DeepSeek, ChatGPT's alleged data breach, and Google fingerprinting. But before we dive into today's stories, here's some background information on our podcast producer, Answer and Evaluate. Answer and Evaluate are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialising in advising clients over multiple jurisdictions. So, kicking off with our first story, Linklaters makes robots sit exams to assess quality of advice. So, this is interesting one. So Linklaters tests include awarding AI programs a maximum of 10 points for each question, with marks scored against overall correctness and the use of citations, as human adjudicators keep an eye out for hallucinations and also for clarity. So according to the article, the questions are described as hard and the equivalent of those that a competent lawyer at least 2 years post-qualification experience could answer in a specialist field. So we're looking at hard questions. You think a lawyer would be able to answer hard questions, but apparently they do have to clarify in this article. 4 different AI models were tested in 2023, so GPT-2, GPT-3, GPT-4, and Bard. At the time, Bard produced a top mark, scoring 4.4 out of 10, but the evaluators warned that all 4 systems were often wrong and that they all produced fictional citations. 2 years on, OpenAI took top honours with a score of 6.4 out of 10, and Gemini 2.0 produced a mark of 6 out of 10. The law firm said in both cases that improvement was driven by material increase in the scores for substance and the accuracy of citations. So essentially what we're saying here is that in the last 2 years, AI development has improved somewhat, but the lawyer warned that despite the improvements, neither program should be used for English law legal advice without expert human supervision. And those are the key words: expert human supervision. Peter, your face says 1,000 words there.
I'm actually just thinking of an experience I had a couple of weeks back where in a non-law firm and non-legal setting, I was in the curated hell of a WhatsApp group. And someone had shared a draft letter to be sent to, in the way it's, a group of angry people saying, we're going to send a letter about this, which probably won't make any difference, but you can but yell at the clouds. And, someone had taken the time to draft the letter. Dear sirs, thank you. We would like you to please do blah, blah, blah. Thank you very much. Yours faithfully. And it was going to be collectively signed. And one of the people on the chat then takes that letter and then reshares it and says, hi everyone, I've just put this through ChatGPT, and as you can see, it's quite different, but I think we should send it this way instead. So this, I think, typified to me the approach that I think a lot of businesses, or even certainly their staff, may have adapted in recent years, of thinking, I'll get ChatGPT to do the easy task for me.
Yeah.
The straightforward thinking. And I think so for a lot of, if you've got to say, draft a letter doing something, or if you've got to do a social media post, an awful lot of things, or it might be, I've got to sit down and write this. People are using ChatGPT.
Yeah.
Law firms are no different, and some people have been using it for general research. This article is making it quite fundamentally clear that even the premium ChatGPT products that you can buy from OpenAI are currently at the moment of being still fairly basic.
Yeah.
To the point that you can't trust them with fairly straightforward tasks. Yeah, in many instances, if you'd actually be better off just doing a Google search to find out a bit of information rather than asking a chatbot to do it. And also the fact that when you're looking for more complex, syntax, language drafting, or please can you tell me where a particular piece of information is or a bit of knowledge, it ain't accurate in rather a lot of those scenarios.
The upshot here is, at least, we're not going to be out of a job anytime soon, because clearly it can't give the correct advice yet.
And before you think, oh, it's the smug lawyer going on that he's more important. Well, no, I get the fact that when we get to the point of artificial general intelligence, which might be only 2 years away, it will, by definition, be at the point where you can rely on it to do those sorts of jobs. But certainly where we are now, in February of 2025, the commercially available products that are out there, as well as the freebie ones like DeepSeek, they can do straightforward tasks for you, but they won't do the more complex stuff. And relying on them remains something that, as the article says, should only be done with expert human supervision, i.e. check what's been done. In the same way that you would, for example, a senior lawyer in a law firm would check the work of a junior lawyer before sending it out. You don't just go, oh, this is fine, tick, off it goes.
Yeah.
But I think it addresses a sort of common misconception that's developing where people think, oh, it's been generated by AI, it's the machines, therefore it must be perfect, and I don't have to check it. Yes, you do. And indeed, you should be checking it with the view to the fact there's more likely going to be wrong stuff in there compared to something that's a human being was put together for you. So while I think there's a stampede to embrace the rule of the machines in many fields, this is still saying for many higher functioning tasks, there is still a very significant risk in relying on the work that AI will do for you. Yeah. Not to say I'm not saying don't innovate. I'm not saying don't use this in a variety of things. Certainly, the stuff that I know that coders are using AI and ChatGPT for that is revolutionary. It's saving time. It means that sites and things and apps can be built far more speedily than before. That's fantastic. The risk here is relying on it for, in this instance, things like, can it do legal research for me? Can it draft a letter for me?
Can it give legal advice, which someone might rely on? And I know that in previous episodes we have discussed the fact that individuals have used AI, ChatGPT or whatever, to draft things that have been spoken in court, and then people turn around and said, well, this doesn't actually exist. Did you not proofread? And therein lies the problem.
Yeah, and indeed that problem again came up in Australia. I think we talked about it in our last episode. For those who are interested, just take a look at that, where there was, I think, a firm in Australia had found a problem whereby a lawyer had relied on ChatGPT, and of course it turned out that the whole thing quoted from ChatGPT was what the developers call a hallucination, but what we would call something that the thing made up.
Yeah,
rather than it being, a real life case quoted in real life case law that you would find on a database or in those old things called law libraries that we seem to be sending to skips. Instead, but the point is that these things as well, not only are they limited to a certain extent, they're only based on the sources of information that they can access in order to train them.
And we will definitely be circling back to that point in our later story in terms of training.
Yeah, because of that, and also it comes down to what, I think we've also talked in the past about the fact that, for example, at the moment, the New York Times is suing OpenAI because they're saying OpenAI has used New York Times content without asking or, most importantly, paying for it. Some news organizations are licensing their content to OpenAI and others, but again, these systems are only good as the data that you give them access to. All of the legal research data out there, in many instances, these chat tools do not have access to them unless you're then using or have developed a premium version that has a back end of precedents and documents and things that have been properly fed into it, then you're going to get a different answer. But the caution here is around your general chat GPT 2, 3, 4, as is referenced in the article there in the Times.
Thanks, Peter. So you'll notice today all of our stories are very linked because we are next looking at a law firm's use of AI. So commercial law firm Hill Dickinson has played down a BBC report that it has blocked general access to several AI tools after it found a significant increase in usage by staff. So the BBC article has said it had seen an email from the firm's Chief Technology Officer, which warned staff about the use of AI tools and said it was only granting access to AI tools via a request process. And then it quoted the ICO's spokesperson saying that firms should not discourage the use of AI in the workplace. And that's just it, actually. So there is a level of, obviously, AI can be used and it can be used to help create a more efficient workspace. But tools should be evaluated. And this is essentially what Hill Dickinson have come back with here. So last week, we sent an update to our colleagues regarding our AI policy, which was launched in September 2024. This policy does not discourage the use of AI, but simply ensures that our colleagues use such tools safely and responsibly, including having an approved case for using AI platforms, prohibiting the uploading of client information, and validating the accuracy of responses provided by large language models. And that really typifies pretty much what you were just saying, Peter, and the fact that you need the squishy blob behind the prompt to actually validate and read through what is being produced.
Exactly.
Because AI can be used and it can be used well.
Yep.
But, and that is a very big but, it must be evaluated and guidelines produced so that it can be used in a uniform way safely.
Yeah, absolutely. That's everything I was going to say. We can move on. No. So absolutely, I think the key point there is that, for law firms and indeed many other skills where you've got sort of highly skilled, highly professional sectors, make sure you've got guidelines around the use of AI. We are not saying don't use AI. We're not saying don't innovate using AI. But in this instance, it was the fact that at this law firm, Hill Dickinson, you had thousands of searches, which they said were actually, individual prompts being put into ChatGPT and DeepSeek, which indicated that those apps were being used on a very widespread basis by their workforce. But they'd never said to their workforce, don't use them. They'd never said only use them for this purpose. They'd never sort of talked about confidentiality, privacy, security. That had clearly never entered into the discussion. If it had, they wouldn't be using something like Grammarly. If, for example, you install Grammarly's bots onto your email or web browser, you've got a problem because then it's looking at potentially all of the confidential information and client confidential stuff that you're going to be working on in your documents. Nothing wrong with, say, cutting and pasting individual paragraphs with no client confidential or private information or say, commercially sensitive information in there and just feeding that cut and paste into Grammarly.
Yeah, absolutely.
Fine. But it don't sort of wholesale lock them out, put a whole letter in there with name, address, all this stuff that is the personal data that we tend to get a little bit hung up on, funnily enough, being privacy lawyers. So, we're not saying don't use them, we're just saying use them responsibly.
Yeah, and with care.
And if you do that, they are fantastic, great time-saving tools that make a difference and make you more productive. And in this instance, at first, the BBC was saying, after this article hit the BBC website last week, they seem to be sort of saying, we've stopped use of this across our firm and we've blocked access to it. And indeed, the Information Commissioner's Office had replied and said, well, when we don't say don't use them, and that's just, it's not a matter of don't use them, it's use these systems responsibly. Develop those guidelines. Take a little bit of time to think, how do we want it to be used safely? And then after you've put it together, don't just say, we've put these guidelines up there. Actually do some training on them. Talk through staff, and this will probably be a different conversation for staff in different departments in terms of how they use it. Your front of house reception staff, you're going to be telling them something very, very different compared to your fee earners, which will be different again to what you tell your IT and potentially your web developers, which could be different again to what you might tell your finance team. So there's loads of aspects here in terms of safe, effective use of AI in these systems. The first step is sitting down and developing some guidelines. And this, for example, is something that we've been working with our clients on over the course of the last year, 18 months, and it can be a little bit of it can be an involved process to actually work through what your client is looking to achieve and how they're handling data and what they're going to do with it. But it doesn't take too long until it starts to coalesce into, okay, well, this is what we're looking at in terms of, safe use scenarios and guidance. And then I say it's just disseminating that so that all of your staff know what is expected. That way, you aren't then hit with that sort of story as it hit the BBC and was then covered by Legal Futures then.
Thanks, Peter. Moving on to our next story, we are looking at DeepSeek. So South Korea has banned new downloads of China's DeepSeek artificial intelligence chatbot, according to the country's personal data protection watchdog. So in case you are not aware of what DeepSeek is essentially the Chinese version of ChatGPT. And I use that as a broad umbrella term here.
Broadest possible sense, yes.
Yes, yeah. There are some key differences.
Yes.
So the government agency said the AI model will become available again to South Korean users when improvements and remedies are made to ensure it complies with the country's personal data protection laws. And there's quite a lot to unpack here from a number of different angles. So yeah. Peter, I'll pass over to you to start.
So we should say that DeepSeek involves in most instances, a download to your system, whereas ChatGPT doesn't. And also, there's a level of censorship on DeepSeek that isn't there on ChatGPT. So you can't ask it everything about everything. And today isn't the day to go into that in detail, but there are key differences. And in this instance, because of, for example, that level of censorship that is applied to DeepSeek and concerns around the download that you have to make, the regulator in South Korea has gone, we aren't happy with this being downloaded. And the key thing here, at first I was expecting to see that South Korea didn't want it being downloaded to government-owned mobile devices. It isn't that. This is a full-on ban. So if you go to Google Play, Apple App Store, it's not there. It's grayed out. You cannot download this if you are working on a South Korean IP address. No. They've banned it. Same thing that was being talked about for TikTok last month is now in place on DeepSeek in South Korea. Now, this is largely because of the geopolitical issues in that region. Bear in mind that it was only a couple of weeks back that the South Korean president was declaring martial law, and then the South Korean president was being impeached. But in both instances, it was because of concerns around security in the region with regards to North Korea, China. I'm not, again, going to go into that in detail. But I think because of that, I think we have to bear in mind that context in South Korea when looking at this decision from the regulator. So it's almost like it's, where it's a 50-50, they've sort of felt, well, there's enough here for us to say we're going to ban it. No Western regulators felt the need to do that yet.
And I will add in here actually that I believe a few episodes ago we actually mentioned the fact that Australia, they've banned it on their government devices. And that is actually the first instance that happened in South Korea. The fact that actually the South Korean government agencies had already banned employees from downloading the chatbot to work devices, but then we have seen this ban extend. And I will note, actually, despite the suspension of new downloads, people who already have it on their phones will be able to continue using it. And actually, DeepSeek can still be accessed via the website. But this is quite a big move. And like you say, considering the geopolitical climate there, not super surprising.
Yes. And it's largely fed by that. I think because this is still a system that only sort of landed with a bang a couple of weeks back, there is still the chance that one of the European regulators or the UK data protection regulator might turn around and raise issues with regards to DeepSeek. I think we have to bear in mind that sometimes it takes a while for investigations to be carried out from a data protection and compliance perspective. It wouldn't surprise me if the UK National Cybersecurity Centre is looking at DeepSeek. Similarly, they did a lot of work on TikTok. They couldn't actually find a problem with TikTok, and in the same way, they never really found a conclusive problem with Huawei devices and systems. It didn't mean that Huawei wasn't eventually banned and stripped out of the UK 5G network, putting back the installation of 5G in this country by several years. Again, that's something we've covered on previous episodes in a fair amount of detail. But point is that do not be surprised if a regulator does turn around and you either find that DeepSeek is banned from government devices or that you get a similar sort of actual ban occurring in other countries. I think at the moment, many of these regulators are, they don't have enough resources to be able to get to grips with a big new piece of tech like this quickly. They don't want to then do a knee jerk and then find that they've found a problem and they start screaming, oh, no, you have to ban this, and then find that the thing that they were worried about isn't a concern and actually betrays that they haven't understood the technology. So I think sometimes there's a let's wait, let's understand it, and then come to a reasoned decision in a matter of weeks rather than a rushing off in a few days and going, no, we want to ban this. I say the geopolitical things in that region have, I think, sort of
expedited that process somewhat.
Yeah, I think that it's sort of, I think the expression's almost, it's sort of taken the hand, it's forced the hand of the South Korean regulator.
Yeah, I think it's also worth mentioning here, something you kind of at the top of the story, where you said that there was a level of censorship. And so obviously censorship in of itself is somewhat of a red flag in terms of the software. But actually on a deeper level, if you've got censorship, the whole point of AI is you have to train it. So if you're training AI based on censorship or what you could say was a bias, where people are then using this, they are not actually going to get a correct or unbiased answer to a question that they're asking. And if you've got such a key piece of information or set of information missing, then actually in terms of the AI functionality, there's going to be a massive piece missing. So if you are then using it, for example, like someone would use ChatGPT, you might get very different answers, even if you compare a ChatGPT answer to DeepSeek. So that's another point that's worth considering here, is the fact that if you have got this going on, the chances are that a human working on the prompt is going to have to work a lot harder to review and check that information that is being spat out.
Yeah, absolutely.
So moving on to our next story, we are actually looking at ChatGPT, and specifically here, an alleged data breach. So OpenAI is investigating reports of potential data breach affecting millions of user accounts, but says it's yet to find evidence supporting the claim. The alleged breach circulating on a hacking forum suggests the threat act has compromised the login details of 20 million OpenAI accounts, including email addresses and passwords. The individual behind the claim offered an apparent sample of the stolen data and is attempting to sell the complete dataset. While the veracity of the claims remains unconfirmed, OpenAI has stated it is taking the report seriously and is actively investigating the situation. So the credibility of the claims has not been verified, but in a statement, OpenAI said it is looking into the reports. So on the surface, okay, we have just got, I say, a normal data breach, but if you're a regular listener to the podcast, we cover a lot of data breaches. But this typifies one of the, I wouldn't say problems, I say friction points that can be found in terms of the use of AI, is the fact that it does lead to potential breaches, particularly where you might have someone who is inputting commercially sensitive or personal data. This is where there is a big red flag, because if there is a breach and you can then access, for example, if a law firm was using it to process client data, you would have a large problem and a big breach on your hands.
Exactly. So this is where the problem that Hill Dickinson identified is illustrated, insofar as if you had staff using these systems.
And this is not to say Hill Dickinson was putting personal data
No,
or
not at
client
all.
data.
And indeed, we're also not, clearly the view from OpenAI is, move on, there is nothing to see here, no evidence that a breach has actually occurred. But the risk is that if you've got 20 million email addresses and passwords to log in, then someone could potentially go into that account and see all of the searches or all of the prompts that have been put in, and those prompts could include, drafts of letters, searches that have been run, legal research, whatever has been put in. And in some instances, people are running, very personal and private things through ChatGPT. So then there is not only are the email addresses and passwords themselves valuable, but the content that's potentially with it hidden inside in terms of the searches that individuals have run could be very valuable. But it just illustrates the point and illustrates the risk with regards to sharing information that really shouldn't be put into prompts on systems such as ChatGPT.
And that really links back nicely to the point we were making earlier in terms of having a clear set of AI guidelines in terms of what should and should not be used for prompts, regardless of the industry or company that you are in. And also carrying out robust training so that you actually understand these guidelines and not just that they exist, but why they are put in place. And that's pretty much typified here in the fact that a breach can happen. And you know what? We go with a not when, but if. No, and not if, but when.
Yeah.
There we go.
Exactly.
So it's just putting the right systems in place.
But this typifies, it's one of the reasons that we try and cover these sorts of things on this podcast, is that very often the response we'll get from clients sometimes when highlighting risk will go, oh, well, this wouldn't really happen, would it? We had this last year with one client going, oh, you're saying, we were saying make sure you've got multiple independent backups. And their response was, well, we use Microsoft 365. That's never going to go down, so we're fine. Of course, a few weeks later, Microsoft 365 went down for them, to which they were then replied, we get your point. This is the same thing here. When we're talking about the risk at the top of the podcast, where we're saying, what's the problem with using these systems? This is what the payback of that is. And whether this is the real or imagined breach, it's illustrating what could happen.
Thanks, Peter. So actually for our final story, we are moving away from AI slightly. We're looking at AI adjacent because we are looking at Google fingerprinting. So privacy campaigners have called Google's new rules on tracking people online a blatant disregard for user privacy. Changes which came into force on Sunday, so that's Sunday the 16th, I believe, of February, permits so-called fingerprinting, which allows online advertisers to collect more data about users, including their IP address and information about their devices. And I will add in here the fact that IP addresses are, in fact, what's classed as personal data. So Google says this data is already widely used by other companies, and it continues to encourage responsible data use. However, the company had previously come out strongly against this kind of data collection, saying in 2019 that fingerprinting subverts user choice and is wrong. But in a post external announcing the new rule changes, Google said the way people use the internet, such as devices like smart TVs and consoles, meant it was harder to target ads to users using conventional data collection, which users control with cookie consent. Privacy campaigners say unlike cookies, which are small files stored on a local device, users have very little control over whether they send fingerprinting information to advertisers. So the long and short of it is that this is a lot more in-depth than your average cookie, and actually you can't really say no to it, so tough.
And it's not regulated in the way that cookies are.
No. You're not going to get that nice big banner that pops up and probably annoys everyone where it says, do you accept all these cookies?
Yeah. But at least you're being given the choice of do you wish to have your personal data taken and processed or not. Many people might go, I'm fine, I don't care. But the point here is that in this instance, your element of choice isn't there. This information will be taken. It will then be potentially very useful to advertisers. And it's also the fact, and I find this quite interesting that they're saying, this more than likely would include a user's IP address. Now, there's some semantics in there where then Google says, oh, well, how people now consume their information online means that an IP address does not betray necessarily an individual. An IP address could be a smart TV with a household of 4 or 5 individuals. An IP address could be an individual on a laptop. It could be an individual on a phone. It could be any other number of smart devices. And bear in mind that sometimes at home you might share a tablet. There could be like a family tablet or used by a whole residence. Similar thing with a desktop PC that could be used for gaming by multiple individuals.
Yeah.
You get the idea. So their argument that a single IP address doesn't denote an individual is indeed compelling and arguably true in many instances. I would take issue with it, though, from the perspective that the EU GDPR is quite clear that an IP address is personal data.
Yeah.
So if it's personal data, it should be treated as such. And the way that fingerprinting appears to be being developed and exploited here suggests that the intricacies requested and demanded through European law are not necessarily being observed. So I'm not talking about cookies, I'm talking more generally about in terms of how it is collecting, processing, retaining personal data. And if they aren't following those things, like, for example, having a basis of processing, adhering to not collecting more data than you need,
specific informed consent,
or whatever basis of processing they wish to rely on. But let's face it, they're not going to rely on contract, are they? If they're going to comply with GDPR, it's difficult to see in many instances how this would do that. And they almost seem to, the argument being run almost seems their argument of saying, well, we don't think an IP address should be personal data. But at the moment, on the face of it, European law says it is.
And also they're saying that it's already widely used by other companies, and it continues to encourage responsible data use. Doesn't really quite match up with...
It fills us with confidence, doesn't it?
Yeah. I mean, it'd be interesting to see. I mean, you mentioned earlier about regulators, and sometimes they don't jump in right away on this, but certainly will be interesting in the coming weeks whether a regulator gets involved. I think I'll say which regulator gets involved first in relation to this.
Well, this is interesting that the cookie law is covered by something called the European e-privacy Directive, which isn't a regulation. It was supposed to be a regulation that would come in at the same time as GDPR did, and it didn't because they couldn't agree on many things around personal data collection, and cookies was one of them.
Right.
So they couldn't agree on a replacement for the banners, which they agree are intrusive and not really what was originally intended when the directive was put through. So e-privacy ended up being stillborn. There's no sort of clear regulation enforcement on that. You just end up relying on the privacy and electronic communications regulations to a certain extent. The point being here that, Europe couldn't agree how to regulate that element of data collection, given that, of course, it was changing and gradually we've moved away from cookies. And sure enough, the technology's moved on. We now have things like fingerprinting and other more advanced, sophisticated technologies that are being developed to do this level of bulk surveillance so that you can get the data that the platforms need to get advertisers, but not going through the increasingly more cumbersome old-fashioned technology of actually installing a cookie on a user's device. Bear in mind that the banners get in the way. You've got an increasing generation of browsers that allow users to restrict the installation of cookies or indeed stop them totally and track, actually tell the user how much they're being tracked. Also give the user the opportunity, the option to have ad blockers and not have this targeted advertising shoveled at them. So therefore, these platforms to an extent are wanting to get around the way that this market is changing, and things like fingerprinting therefore become a valid way in their eyes of doing that. So this is part really of that wider sort of struggle, if we look at it in that broader context. So yes, cookies are gradually, you find that developers now tend not to install many cookies. We do a lot of this work with our clients where we end up putting together these cookie schedules. If we were working with a developer 5 years ago, sometimes you'd get page after page after page of cookies. But I'd say around the time of the pandemic is when we noticed that started to drop off a cliff. So increasingly, the last 3 or 4 years, developers are not using cookies. They're using other things. These platforms using things like fingerprinting. There are other systems out there, but they're basically trying to get the same data or even more richer data while circumventing the regulatory issues that are in place around cookies.
Thanks, Peter. So that rounds out all of the discussions for this episode. And if you have any questions about anything that we have talked about today, please email us at admin@digitallawuk.com. A summary of today's stories are available on our website, as well as the links to the original stories containing more information. If you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Answer and Evaluate for helping to produce this podcast. And if you'd be interested to hear more about Answer and Evaluate services, please take a look at their website that you can find at www.answerandevaluate.com. And finally, just a reminder, these episodes are available on our website, YouTube channel, podcast channels such as Spotify, Apple Music, Amazon, and please feel free to leave us a review. Thank you for listening, and we hope to see you again next week.